Right, great. Good morning, everyone. I hope you're keeping well and that your families are safe, and as yourselves, you're keeping safe and everything is going well. I mean, we live in unprecedented times, and so we really need to make sure that we don't take certain liberties that we've enjoyed for granted. So my name is Maxwell Okello. I will be moderating this morning's webinar. I'm the Chief Executive of the American Chamber of Commerce. And thank you all so much for turning up in great numbers to join our webinar this morning that will be looking at the legal implications around COVID-19 from various perspectives, and I'll be talking about that soon. Just a few housekeeping notes, just for you to be cognizant of. One, the webinar will be 1 hour long. We'll really try and keep time so that we are able to, cover what we need to cover within that time. As you join, you realize that your video and your audio is actually muted or turned off. This is so that we are able to really be in control and have a good experience during this session. And so we ask you that when we get to Q&A, or as we are moving along with the webinar, if you have any questions, please use the Q&A chatbot on the bottom of your screen. There's a Q&A chatbot on the bottom of your screen. Please post your questions there, and myself and the panelists will be able to see that, and we'll be able to field the questions when we get to Q&A. We will run through the 3 presentations, sequentially. And then after that, I will open it up to the Q&A, and hopefully at around 10 a.m., we should be able to close today's webinar. So to begin off, I just want to thank you all for making time to attend, and a really special thank you to our good members, DLA Piper, IMMIGR advocates, Dentons, Hamilton, Harrison, and Matthews, and Fragomen for partnering with us for this webinar and to share their insights based on what they are doing to assist and support businesses both locally and globally to navigate the unique challenges that COVID has presented. This webinar is actually one of our series around the response to the COVID-19. And what we're really looking at doing is bringing to the table some really critical thought leadership, conversations and aspects that enable business leaders or equip them with critical information that they can use to enable them to make the right strategic decisions during this crisis period. Today's session, as I mentioned before, will focus on the legal implications surrounding aspects such as restructuring and insolvency, employment, and immigration considerations that business need to take into account as we get into the recovery phase, and hopefully that will be sooner rather than later, in what we've come to know as our new world order, so to speak. And today, we have with us Judy Muigai, who will speak on the implications of restructuring and insolvency, with a focus on the role of company directors. We have Ezra Makori, who will speak on the implications from an employment perspective, understanding the responsibilities of employers and indeed employees during such times. And Mucee, who will speak on the implications surrounding, or rather implications from a COVID perspective on immigration matters. And so I'll just very, very briefly give their bios before I hand over to our panelists today, or our speakers today, to take it home. So I'll start off with Judy. Judy Muigai is a director in the Projects Energy and Restructuring Practice Group of DLA Piper IMMIGR Advocates. Judy currently focuses on advising large local lenders and DFIs on substantial restructuring and insolvency matters involving players in manufacturing, retail, transportation, construction, and financial sectors. Judy has also advised publicly traded companies with subsidiaries in the region on restructuring their debt to preempt a distressed situation. Having previously worked at PwC and GE, Judy has also advised companies across several African countries on legal and tax implications of their transactions and projects. Ezra Makori is a partner at Dentons, Hamilton, Harrison, and Matthews. He is part of the litigation team and is a member of the employment, banking, and finance, environment and planning, and real estate practice groups. He has vast experience in employment-related litigation and is currently a member of the Court Users Committee of the Employment and Labor Relations Court of Kenya, which has representatives from the judiciary, Law Society of Kenya, and all stakeholders in the justice sector. George Mucee is Fragomen's practice leader in Nairobi, where he manages client accounts and provides government relations and strategy advice. George manages a team of immigration professionals within Nairobi or within the Nairobi office, and is responsible for the service delivery to clients across the East Africa region and to manage Fragomen's strategy across the whole of Africa. He previously worked with the government of Kenya in various capacities, including border control and management. And George has also been an advisor to the Bureau of Immigration and Naturalization of Liberia under the United Nations Mission to Liberia. In addition to that, George has helped draft and reorganize Kenya immigration regulations and processes involved in the issuance of work permit and passes to foreign nationals in Kenya. So as you can see, we have a very, very preeminent panel to speak to us this morning. And without much further ado, with those brief remarks, I want to turn this over to our speakers. Thank you, and over to you, Judy.
Great. Thank you so much, Maxwell, for that introduction, and welcome everybody. It's a joy to have you with us this morning as we look into some of these issues. So Maxwell has done a great job of introducing me. I'm Judy, and I am a director with IMMIGR Advocate DLA Piper Africa. And I hope you're all keeping well and safe. Now, COVID-19 has been on everybody's lips. And I think today is an important session because we'll be looking at some of the legal implications. Obviously, there's a limit to how much we can cover, but let's jump right into it. My piece will really be on some of the insolvency and restructuring implications, and really focusing on what directors' responsibilities are in light of that. So please keep your questions coming through in the chat, and we'll see how many we get to at the very, very end. Okay, so in terms of what I will be covering, really it'll just be around directors' responsibilities, especially in cases of doubtful solvency, and also thinking about what kind of practical steps can be taken to manage those responsibilities. Right, so starting, I think, from the drawing board, it's really looking at what directors' duties are in a case of solvency, in an ordinary situation. And there's a raft of things to consider, but just to mention that really the key constituency for directors for a solvent company is the shareholders. There's many other things that need to be considered: employees, suppliers, customers, and so on, but the key constituency is the shareholders. And in that regard, directors have responsibilities to exercise independent judgment, exercise reasonable care, and a whole bunch of other fiduciary duties. Now, what happens in a case where you have a company that's not solvent? So what we have is, in the Kenyan Insolvency Act, we have what we call wrongful trading provisions. And under these provisions, a court can make orders for a director to contribute their personal assets to that of the company if they knew or ought to have known that there was no reasonable prospect that that company would avoid going into insolvent liquidation, and they did not take steps to avoid potential losses to creditors. And the courts have really emphasized that point, that really if a company is either insolvent, of doubtful solvency, or on the verge of insolvency, then directors' focus really has to shift a little. So they still consider shareholders, but really some of the focus now switches to creditors, protecting creditors from suffering greater losses. So really, directors now have to turn their minds to the potential losses of creditors. Okay, so you might then reasonably ask, how would a director know that the company cannot avoid insolvency? Again, there's many moving parts to this, but the Insolvency Act at least has defined a case where a company is said to be unable to pay its debts. So there's a bit of a threshold there. So if there's a debt of 100,000, the creditor has demanded payment and payment has not been made within 21 days, so that would qualify as a company being unable to pay its debts. But there are other things which directors would also need to consider when trying to determine or assess whether there's a solvency issue. So that could be an express or implied agreement with a creditor for an extension of time. There could be a well-established course of conduct in a particular industry. Again, it's hard to kind of give a finite checklist for these things, but there's a number of things that need to be considered. So what would we recommend in this regard? So where, that should be where solvency is doubtful. The insolvency laws refer to what a director knew or should have known. And again, some of that is a reasonable, it's a test of a reasonably diligent director. What should they have known? So, ignorance may not be a defense. So directors really have to make sure they are obtaining up-to-date information and really querying the status of the solvency of all the companies that they are directors of. Then a key point, and we did see, I think, a number of advanced questions coming in on these issues, is really around whether there is a reasonable prospect of avoiding insolvency because there are viable options to avoid insolvency. And there are so many things that can be thought about on this subject. I think I've just put a few there where we're looking at, what is provided for in the finance agreements. Are there grace periods? Is it possible to claim force majeure? And I think there's been a few questions on force majeure, what we call FM. Now, FM is a contractual remedy. So it would actually depend on what the contracts actually say. And I think, you may find that a lot of financing agreements don't actually have FM clauses. Yours might, but it's important to actually look at what it says. Force majeure is a, it's a remedy that kicks in because there's a provision in a contract which says something like there's an event which is beyond the control of the affected party. And because of that event, they are unable to perform under a certain contract, or they will suffer severe delays in attempting to fulfill their obligations. But again, the wording of the clause is crucial because chances are that it lists the kind of events that qualify. So it's difficult to say whether COVID-19 would qualify or not because that is dependent on what the clause actually says. Then there's another question or another issue around whether there's other legal remedies. So I think there's been quite a few questions on the doctrine of frustration. That is a common law principle, and it kind of refers to cases where the circumstances have rendered the contract incapable of being performed. And the threshold for that is actually very high because hardship is not enough generally when someone is trying to make a case for frustration. It's, the bar is really, really high for that. So making claims of that nature, it would have to be something very, very compelling. Frustration also refers to a case where the circumstances have kind of changed the whole nature of the contract. It has changed it from what the parties intended. And again, the threshold for that is really quite high. Now, there could be concessions available from lenders. I think we've seen offers from our local banks in line with the guidelines that came from the Central Bank of Kenya, kind of encouraging the giving of payment holidays or payment breaks for 3 months, extension of loans, and all sorts of things. And I think there's been a lot of effort to try and push on the banks so that they can then kind of pass on some of that relief down to borrowers. And I think we've seen quite a bit of that in the media. But it's important, you know, there could be some blanket provisions, but it still makes sense to go to specific lenders or creditors and really have that discussion with them. I think a lot of that will be on a case-by-case basis rather than kind of blanket concessions or blanket approvals. And, you know, as lawyers, I think we would always recommend that it's documented, you know, how much of a payment holiday, how much of an extension, are you clear about what it means from an interest perspective? Just make sure there's some clarity on that. Then it's important to consider whether there's any feasible restructuring options. So, you know, there's so many things. There's a full kind of a bag of tricks on this. You know, there's debt to equity conversion, cash calls from shareholders. So there's so many things that can be considered. Are there non-core assets that can be disposed of? But really, it's important to go through the motions of analyzing what the options are and determining whether those options are viable or feasible enough to prevent the company from slipping into insolvency. Another key point, so I think we mentioned wrongful trading on the slide, the previous slide, but again, where solvency is doubtful, again, directors have to think about whether they are trading in circumstances, whether they're allowing the company to trade in circumstances where they should actually cease trading, or whether ceasing trading actually creates greater losses for the creditors, in which case closing the doors and kind of bolting them is not the answer. Okay, what else should directors be thinking about if solvency is doubtful? Really avoiding transactions which could be set aside in the event of liquidation. So, you know, there's certain transactions which, if entered into within a certain period before the company slips into insolvent liquidation, those transactions could later be set aside. They could be reversed or unwound by the courts. So those are, for example, the ones which create a preference for one creditor over others. So if, you know, if there's an attempt to kind of improve the securities for one creditor over the others, because you know that, you know, things are coming to a head and you want to make sure that one creditor is safer than the rest, or transactions which are done at an undervalue because, you know, you can kind of see the writing on the wall and you know, there's an intention to accomplish something in advance. So again, some of those transactions, they are called vulnerable transactions, could be set aside at a later point. Directors also need to comply with other requirements under their contracts, company policies, articles of association, and even statute. And here I think we flag disclosure obligations because, for example, for listed companies, there's a requirement to disclose information which could have a material effect on share prices. So if there is an impact of COVID-19 that really could have a material effect on share prices, again, it's important to be aware of the disclosure obligations and to fulfill them. And there could also be a whole bunch of other company policies and requirements that directors still have to bear in mind and fulfill, even at this difficult time. Okay, then on to what are the risks for directors. So in the case of, say, wrongful trading, again, a court could issue orders to the effect that that director has to contribute their own assets to kind of as restitution for the creditors. So really to contribute to the company so that the company can then distribute that to the creditors who have suffered a loss as a result of the director's actions. Another risk is potential disqualification from acting as a director or company official for up to 15 years. There's also a possibility of criminal prosecution, but the bar for that is quite high. It would be, I don't know, a case of fraud or embezzlement or something like that. But yeah, that's still one of the risks. And then there's occasions where that director has, or rather even in their capacity as a shareholder, has issued guarantees and maybe they've even put up personal assets as collateral. And again, those could then be invoked in that situation. So that constitutes a risk to directors. How can these risks be mitigated? Really cannot emphasize this enough, to get kind of very fact-specific professional or legal advice on what the options are and what the risks are. Really, and some of that advice can even be useful when it's time to look back, because it will prove that the directors considered certain things. Then the directors also need to be kept up to date on the information around the company, the status of their creditors, what they can and cannot pay, and things like that. So it's really important to have detailed, up-to-date, current, and reliable information being fed to directors regularly. Now, holding and documenting regular board meetings wherein creditor issues are considered and discussed, I think that is also crucial. You know, I hope we are not one of those countries where you'll find a lot of directors are either unwell or sadly may even have passed away as a result of the pandemic. So here, I think, you know, most companies should be able to hold remote board meetings, but again, it's important to look at the articles of a company and see what they permit in that regard. So I think that's it from my part, but I will be happy to take questions a little later. Okay.
Thank you very much, Judy. Ezra?
Sorry, I was on mute. My apologies. Thank you, George and Judy. Mine is now to take us through the employment part. As we know now, there is a new normal. We are told there's social distancing. People are talking of unpaid leave. So all these have to be looked at from the perspective of what the law says. Each party, being employers and employees, will have obligations in the new normal, but we'll need to look at the law as currently is to see what can we do as we take the measures to mitigate the effects of COVID-19, what are our obligations under the law. So just to start us off is to understand what laws apply to the employment relationship. And I must just state here before we delve into this discussion that I'm not trying to give legal advice. We're just trying to look into the law and see what our obligations are. Of course, there are parameters. There are other considerations to be made if I'm to give legal advice, including confidentiality, how you disclose information to me. So in this discussion, we're just going to have an overview of what really our obligations are under the law. So in terms of the employee relationships,
Ezra, before you go on, please, can you just turn on your full screen, your presentation mode, please?
It is okay now?
Yeah, that's fine.
Thank you.
All right, sorry for the interruption. Please go on.
Part of the new normal we're trying to learn is to use these softwares. So these are the laws governing the employer-employee relationship. You start with the Constitution of Kenya, which is key, come to the Employment Act. I'll run down to the Employment and Labor Relations Court Act. There's a last act there which I have not listed, the Data Protection Act, which is a new law. So that's what we look at. Now with the COVID-19, perhaps employers need to know what their obligations are. For instance, if we had, how do we cushion our employees from contracting COVID-19? If an employee was to contract COVID-19, either at the workplace or outside, what are the employer's obligations? So under the Occupational Safety and Health Act, OSHA, as we know it, there's a duty on the employer to provide for the safety, health, and welfare of the workers who are and any other persons who are lawfully present at the workplace. So, given this duty, employers should then appreciate that it's an onerous duty, which means that if an employee then was to exhibit symptoms of COVID-19 or test positive, the employer will have obligations to inform any persons who have come into contact with this employee. This would include the colleagues and the government of the positive case. Also, under the Public Health Act, as we are all aware, the Minister for Health recently promulgated some rules to guide us in how to mitigate the effects of COVID-19. The workplace has now been designated as a public place. And now this comes with a new angle that we are now required to exercise social distancing, number one, even at the workplace. We are required to wear face masks at the workplace. I have mine. We are required to provide hand washing soap and sanitizers at the workplace. We are required to sanitize our premises as employers, and that any employer who contravenes these rules commits an offense and may be liable to, upon conviction, to some penalties which are set out in the law. This then also, as you recall, there's the curfew under the public order variation, the variation of the curfew order 2020. Now employers are required to ensure that employees leave their workplaces not later than 4 p.m. unless you're providing essential services. And the minister did set out, the Cabinet Secretary for Interior did set out what essential services are in that order. This means that the hours of work are now varied because you cannot be found walking around from 5 a.m. in the morning, from 7 p.m. in the evening until 5 a.m. We will come to that later, what this means to the existing contracts of employment, which has specific working hours. Then, given these developments, that we have an obligation as employers to disclose employees who contract COVID-19, we have an obligation to provide some masks, ensure social distancing. What is our responsibility as an employer? The employer may then choose to introduce some protective steps, which we have set out, that, but just to highlight that it's now prudent for an employer to ensure that they create awareness to their employees on the COVID-19 and the preventive measures, open some lines of communication so that the staff can share their concerns, provide sanitizer stations throughout the workplace, and ensure that the place is regularly cleaned, and limit face-to-face meetings. Employers are particularly encouraged to ensure that they embrace technology. We are aware as practitioners, as lawyers, that even the courts are now trying to embrace this technology in conducting the court business. Next, we move to what is then the obligation of the employer where an employee exhibits symptoms or is placed under quarantine. What is the employee entitled to under the current law? The Employment Act entitles an employee to sick leave. Under the Act, whatever sick leave entitlement is given is the bare minimum. Our various contracts of employment will have also various entitlements, but we cannot go below that which is in the Employment Act. So it's important that we check our various employment policies, the HR manuals, contracts of employment, to confirm what amount of days an employee is entitled to as sick leave. Because then if I test positive at the workplace, I would be entitled to, I would be sent to quarantine, I would be treated. I should then benefit from the sick leave. As you are aware, government is now asking people to disclose if you suspect someone has COVID, is exhibiting COVID-like symptoms, or if an employee has tested positive, the employer will be required to disclose some information. But we have a new law, the Data Protection Act, that protects some data, which is personal data. Does then an employer have to disclose this information regarding COVID-19? Where do they stand? In our view, given the legal obligations placed by the various instruments that have been promulgated since the COVID-19 pandemic was declared a pandemic, the employer will have an obligation to disclose the personal data of an individual if it's necessary for purposes, for reasons of public interest or for public health as required by the regulations. Also, if a person tests positive, the ministry will be entitled to inspect your premises as an employer. And this then means that you might have to give access to your premises to the public officers to come in and fumigate. Now, having looked at the possible effects, our duties, what is likely to happen, what then do we need to do? As we know it, our current contracts do not have a provision for such pandemics. However, if you go to Section 10 of the Employment Act, it does contemplate that terms of employment might be changed. Only one obligation it places is that employers and employees must consult. It should be the other way around. The employer must consult with the employee. Now, this section is silent on the issue of consent, whether then having consulted, you need to get the consent of the employee. But the fundamental thing to pick from the current Employment Act, and then the case law that has been determined based on that section, is that if there is need to adjust employment terms because of the special circumstances we find ourselves in because of the COVID-19, then you have to consult the employee. What are the businesses doing? What are employers looking at in terms of mitigating COVID-19? Remember earlier on in the discussion, we said there's a curfew. If you're not an essential service provider, you're required to release your employees by 4 p.m. If you have, for example, a working cycle of 8 hours, I doubt it will be possible to have your employees working for 8 hours and yet leave the workplace at 4 p.m. So this also has a trickle-down effect. If you're providing services to third parties, they're closing at 4 p.m., which means maybe you have to have your people leave as a service provider earlier. Some workplaces have totally closed because of the effects of this COVID-19. We know particularly the hotel industry is adversely affected. The airlines, who are the international airlines, most of them have closed down totally. What does this mean? This means that some employers may not have work. When an employer does not have work, it means the employees then have nothing to do. What then do we do? The employers then are encouraged to adapt measures to encourage and enable employees to work from home for those that have work. If there's a reduced workflow, then employers will be encouraged to introduce flexi time or rotation so that whatever little is available can be shared. If then there is nothing to do, employees then and employers have to consider the issue of unpaid leave. I've seen some questions in the Q&A about it. We will cover that there. The other possible discussion that now parties have to have is pay cuts. I mean, if then the worst comes, that there's no work, there's no more revenue to even consider pay cut, the law allows that you terminate the contract lawfully through redundancies. So some of the key issues we have identified that you can take as an employer to address COVID-19 But as I set out in the slide, you analyze the best method to mitigate, because it will vary from employer to employer and from sector to sector. For example, a law firm might not be facing the same challenges a security services provider will be facing, or an airline, or a hotelier. So the solutions we have will be different, but they have to be within the law. So we look at the best method as a specific employer in a sector, communicate and be transparent with employees, consult with employees. Where there's a union under Section 10 of the Employment Act, you are required to consult the union and get their consent. Once you get their consent, then effect the change, have them execute, and you review the situation as time moves. Some employers are saying, let's look at 6 months, let's look at 3 months. It will depend on a case-by-case basis. But if at all there's no work, as we said earlier, and you have to restructure your operations, then unfortunately, we have to discuss redundancies. The law fortunately recognizes that an employer can lawfully terminate contracts when they have to restructure their operations through redundancies. But you have to follow the law. You have to pay out what is required. So looking into the future, under our laws, we, unfortunately in our jurisdiction, we never contemplated the issue of force majeure in employment contracts. We have not explored frustration in our employment contracts. Maybe going to the future, we might have to rethink and see whether this is the right time to consider clauses that provide for temporary layoffs, force majeure. But I would advise every party to take independent legal advice on this and see how best it sits into the specific circumstances. As an organization, we do have a platform where you can track and follow us on what we are giving our clients in terms of the mitigation measures to COVID-19. I have provided the link there. If you click there, you'll be able to follow what we are providing to our clients globally. I have several questions which will be tackled later. Once George makes his presentation, I thank you for your time. George, please take us through the immigration aspects.
Thank you very much, Ezra. George, over to you. We are running out of time, and so we want to make sure that we take as many questions as possible at the end of it. And I'm sure George will be concise with his presentation. George, please go ahead.
Thank you very much, Maxwell. I hope you guys can hear me in a clear manner. Thank you very much also to my colleagues, Judy and Ezra, for the good presentation. Now I will be summarizing by taking you through, the impact of COVID in East Africa from an immigration perspective. This is a very high level overview, and we will come back to this slide in terms of the talking point. But I want to take you through what's happening in the region. Generally in the region, in East Africa region, including Ethiopia, countries have either done full or partial lockdown. There's partial lockdown in Kenya, no international travel. Most of the government offices are scaled down. In Uganda and Rwanda is full lockdown. So nothing is happening. Immigration offices are closed. They don't form part of the critical services. Rwanda and Uganda. Tanzania, surprisingly, is business as usual, but the numbers are spiking really, really quick. So we are waiting to see how they're going to respond to that. Ethiopia is on partial lockdown. Immigration offices have suspended work. There's a bit of limited movement too. Burundi there's no lockdown, but it has suspended flight to and out of Burundi, but government offices are operating normally. In terms of how government reacted in Kenya, when the first cases were discovered, the government reacted by giving instructions in terms of first, saying we will not allow people traveling from some countries with confirmed cases. But then thereafter, they they gave further instructions in terms of partial lockdown that we are seeing in the country, with some counties in lockdown. But generally, what we need to ask ourselves is then, how do we navigate the immigration landscape in these times of coronavirus? And that is where we will come back to issues, the talking point I had earlier spoken about in terms of the questions. A lot of the questions we are getting, people are asking, what is the fate of foreign nationals in Kenya with expired or expiring immigration status? And how should companies with employees with expired or expiring work authorization proceed to have them work in a compliant manner? And then, of course, the very last one is the government of Kenya considering any concessions from an immigration perspective? Now, to respond to the first two, what is happening is, if you're traveling on a visa in Kenya and for some reason, because the flights are grounded, you are not able to travel, the government of Kenya has introduced a provision, an online, where you can get in online and apply for an extension of your visa, which will be done entirely online, and you'll receive a notification that your visa has been now extended for this and that period. But remember, visas do not allow you to work. So then the question is, where companies have employees that have been on work permit or passes, and those are either expiring or expired, then how are they supposed to work compliantly? There is no solution so far given. The government is adopting a business as usual model, where you just they're continuing with the usual application for work permit. The submissions are being done online, but also you drop the actual applications in a Dropbox app submitted. But then there is no, because of the scale down staff at immigration to ensure that they do not risk infection, the process is very slow. But they have not communicated, like we've seen in other countries, where they've said, if you have a valid permit or that is expiring within the year, then we are giving a blanket extension, like we've seen in Dubai and other countries. In Kenya, it's slow. So the question therefore then is, for how long will this hold up continue? I must say it's a wait and see. We do not have any clarity on that. And then on the issues of concessions, we've not had anything from immigration so far, or from government in terms of the government fees or any other concession. But it's a wait and see, really. So ideally, what we need to know is, this will not be a permanent feature in our lives. So therefore, then the question is, how are we supposed to navigate? I think my advice to employers and everyone is, you need to think on your feet, get ready, have whoever is advising you on expatriate or the people that you're hiring, be ready so that whenever a window opens that allows you to, to be able to make submissions and to regularize their stay, for you to be able to do that. In the interest of time, I wish to stop there, but we at Fragomen have been monitoring globally what's happening around immigration, and on our website you will find a microsite that at the click of a button you're able to get everything. In case you want to talk to us, you could talk to us. And I want to stop there and see if there are questions that will come in. Over to you, Maxwell.
All right, thank you very much, George. Thank you, Ezra. Thank you, Judy, for those great insights that you've shared. We're receiving quite a number of questions coming in through the Q&A chatbot. And I'll quickly just launch into the questions. We'll try and cover as many as we can in the time we have left. And perhaps I'll start off with you, George, since you spoke last, just picking up on what you talked about. And one of the questions that have come through is, given the current model of working from home, do you see, in your view, from your vantage point, an impact on the work permit applications for future staff? Perhaps a requirement to prove the need for physical presence of the employee in the country vis-a-vis them working remotely on a consultant basis, for example, to support local staff. Do you see, some sense of movement in terms of a consideration, in terms of that changing in whatever way our immigration stands?
Thank you, Maxwell. That is a very valid question. Ordinarily, the Department of Immigration would look for all reasons to decline applications that they think are for jobs that can be done by Kenyan or otherwise. Yes, I think this one in particular, because the world as we knew it has really changed. This is a new world. So I don't see anything that stopped the government from saying, look, if this guy is a consultant and we have proven that we can work from home and from wherever we are in the world, why can't this guy provide support from wherever they are? And I mean, you give jobs to the Kenyans. Yes, so it's possible. After this coronavirus, I think a lot of things will change, and I think immigration will look at how they process work permit, and this could be a big consideration. They could say, well, look, we are not going to give you this permit. You can have your guy support the Kenyan team from wherever they are. So I think, yeah, I think it's true. This will most likely impact our immigration process.
All right. Okay. To Ezra, where do you draw the line between the needs of workers or employees at a time such as this and the needs of the business? And this is an interesting perspective, because we're dealing with a reality here that is very, very true. And how can then business navigate that situation better, and not to seem like it's unnecessarily unfeeling or heartless, given that we're in this sort of crisis? I mean, employers need to do what they need to do, but at the same time, there's just the reality of the fact that, we're dealing with people, we're dealing with workers here. Is there any provisions, or from your vantage point, do you have anything that you can share on how, businesses can handle this?
Thank you, George. I think we all agree that COVID-19 has ushered in a new normal. That poses challenges in view of the existing legal framework and our contractual obligations, both the employer and the employee, the obligations we have under our existing contracts. So as I highlighted, and I'll go back to the slide where I highlighted what we should consider doing, even as we try to navigate this space, it's important that we have very candid discussions. From the employer perspective, you need to communicate to the employees the position you're in, the challenges you're facing in a very transparent manner. Consult with the employees, because consultation is a legal requirement. Where there's a union, consult them and get their consent. Anything you want to then effect, if it's a change to the existing terms, for example, if it's unpaid leave, if it's a salary cut, if it's a redundancy, follow the law, get the notices served as per the law, as required by the law. If you're effecting salary cuts, make sure you get variations of contracts. The main thing is how you communicate to employees. It will be fundamental here, because both parties will have to realize that we're in this difficult time that no one planned for. When we were entering our contracts of employment, we had hoped for the normal to continue. We had hoped for the best, but now this COVID has come in and it's no longer business as usual. Mm-hmm. Because if we continue with business as if business is usual, then we cannot sustain it. And as employees, then you have to show them that if we continue this way, then our jobs are also at risk in the very near future.
Yeah. Okay. Thank you. Thank you for that. To you, Judy. Countries such as Australia, providing directors with temporary relief from insolvent trading liability, increasing the thresholds for commencing winding up and bankruptcy proceedings, as well as relieving companies of the obligations to deal with unforeseen COVID-19 circumstances and avoid insolvency. Are there similar measures or provisions being considered here in Kenya?
Yeah, Maxwell, that's a great question. And, it's not just Australia. I know even the UK, I think, has suspended their wrongful trading provisions for 3 months. So it is important to have kind of temporary measures in place. In Kenya, we've not seen those yet from an insolvency perspective, although there's a raft of other measures, you know, to do with tax and other things that have been done. But the value of some of those insolvency kind of suspension of some of those terms is to avoid a situation where companies which would have weathered the storm are now kind of sinking into a hole from which it will take a very long time to recover. So, you know, there kind of does need to be some temporary measures. So, for example, the threshold of 100,000 shillings or 21 days or things like that, which can either be expanded or extended or suspended. I think that would be a good thing to have.
All right. Okay, great. There's also a question here directed at you. The question is, you know, in Kenya, can directors' liability be eliminated through D&O insurance?
Yeah, so there, in the Companies Act, there's nothing to prevent a company from taking out insurance for directors' liability. But insurance can only really protect, I think, from a financial perspective. So if that director, say, is liable for disqualification, or if there's any criminal charges that can be brought, then insurance may not help in that situation, but it can help with the financial aspect. Yeah.
All right, thanks for that. So I'm going to do some rapid fire questions as I keep running through the questions as they come in. To Ezra, does the employee or employer law apply to organizations and multinationals based in Nairobi as well?
Thank you, Maxwell. The answer is yes. The Employment Act provides that the Kenyan law applies to all employees working in Kenya. So if the employer is based in Kenya, our Kenyan law will apply.
All right. And is there a responsibility for the, I actually think you may have addressed this, but just to reiterate, does the employer have a responsibility to cover the cost of hospitalization or healthcare if an employee ends up being COVID positive?
No, that will have to be looked at on a case-by-case basis. Mm-hmm. But fundamentally is the fact that in normal circumstances, the employer is required to provide medication at the workplace. And this has been taken to be basic medication. The cost of healthcare is usually not covered by the employer unless the employer has a health insurance scheme in place, which then cushions the employees. So, however, if you're talking about the employee having contracted the COVID-19 in the course of employment, then that has to be looked at on its own and considered as a case of its own. Okay. The employer will have to take advice on whether they would be liable for the cost of medication for that particular employee. But generally, the answer would be the employer would not be liable, generally.
Okay. All right. George, a question here on basically trying to get some clarification on what happens to the alien card, as technically it will, you know, it will also have expired. So what is the cost? What is the recourse rather?
I think now if in Kenya your status is expired or your alien card, you just have to wait, make sure, because they are not receiving, the public facing sections of immigration have been closed down, and we can only do an online application, but then you cannot submit the actual documentation unless you do them. Like the alien card, you need to have your fingerprint taken, so that is not happening. So people will have to wait and see. It's a very unprecedented times. No one should expect normalcy or you to be harassed for not having a valid card for now, because it's on them. The government is not issuing them, so you cannot get them from a shop downtown or from any other place.
Okay. All right. And Judy, is there case law of actual action against directors in the instances of insolvency?
Yes, so there are some instances where there's an order, a decree against a company to kind of go after that company's assets. Now, where the company doesn't have assets left and it's proven that the directors kind of diverted funds, then the order against the company has been executed executed against the directors. Yeah, so there are those cases.
Okay, all right. And then there's this issue of force majeure keeps coming back, and maybe an opportunity to just provide some clarification. There's a question here that's asking, how will courts deal with force majeure claims consistently when there is presumably no precedent or precedent cases dealing with the situation of a global pandemic?
Yeah, that's a little tricky because force majeure is a contractual remedy. So it will really depend on what a certain contract provides for. And I think the hope is that if those force majeure clauses are properly invoked, it doesn't even need to get to a court. It's kind of writing a notice to the other party in the contract and issuing that force majeure notice. It would only really get to a court if there was a dispute about whether or not it qualified as a force majeure event. So it's really important, I would say, to get a bit of professional advice on that before issuing such a notice. Yeah.
Mm-hmm. Okay, and one more question here for you. It's a bit of an interesting question. You know, there's a startup who's basically got in investment and has been severely impacted by COVID. So I think the question here is really around what sort of implications there are. I would imagine this would most likely be contractual, but what sort of, in an instance where you've got an investment and severely been hit, what happens? What happens?
Yeah, that's a good question and a pretty loaded one. I think it would mean kind of going back to, as you say, that the contractual agreement. So if the main concern is whether or not that startup can repay the debt that kind of debt investors have used to fund the startup, then it would mean kind of looking at whether the contract provides for any kinds of extensions, grace periods, things like that. If it doesn't, I would still say kind of approach the other party and see if it's possible to restructure or reschedule that debt, or to even consider restructuring. Is there, are there, I don't know, a venture capitalist or somebody who is willing to kind of pump in money to kind of save the startup? So there could be a raft of options, but I think one would have to go through the motions of examining what those options are and which ones are the most viable. But I think the key first point is to try and get some time if creditors or lenders are owed money in the immediate term.
Yeah. And to our final question, I think we're running out of time. To you, Ezra, there's somebody who's asking that WIBA is not covering COVID-19. So if a staff ends up with the disease in the course of duty, of course, and either dies or recovers, can one claim damages from the employer in regards to failure to ensure a safe work environment?
Thank you, Maxwell. I think I covered partly that question in my last answer.
Okay.
This question, I would like just to provide a general answer with the risk of giving legal advice. One, it will depend on the circumstances. It's not clear from the question whether the employee has contracted COVID-19 at the workplace. I don't think it will be absolutely correct that WIBA cannot cover such an ailment if it's contracted at the workplace. So I'll just tell the person asking, we will need more facts. We will need to know whether this is contracted at the workplace and why specifically WIBA is not covering. It will have to be determined on a case-by-case basis.
All right. Fantastic. We are out of time. I just want to, as we come to the close, we have one request. For those who are participating, we want to basically invite you for a few seconds to fill out our poll. It should be appearing on your screen right now. Just basically quickly click what you think and submit that. And really, you know, as that is going on, I want to most sincerely thank DLA Piper Africa IKM advocates, Dentons, Hamilton, Harrison, and Matthews, and Fragomen for their partnership and the great insights that we've shared this morning. Thank you so much for availing your time from your busy schedules and really engaging with us this morning. As you can see, the feedback is great. As you can see from the chat box, we were not able to cover all the questions. We will see if we can actually have those you know, covered for you, for those who asked questions and are not answered. And then we will be able to send those with the presentation at the end or later on once we've concluded and gotten the feedback from our speakers. Thank you very much, Judy. Thank you, George. Thank you, Ezra, for, you know, speaking to us this morning and sharing your wisdom. And thank you all who've participated in this webinar this morning. Please look out for our digital transformation series starting next week with a discussion on the future of work. And with that, we've come to the end of this webinar. Again, I want to just wish you all a great day, and please do take care of yourselves and keep safe. Finish the poll, and it will be really, really great to host you again next week. Thank you very much.